Caldwell is here for sentencing. As you can see, he was recently a passenger in his vehicle with his wife and was in a wreck. They brought some paperwork from the hospital. He's supposed to be sentenced to serve a minimum of 120 days because it's a DUI Ford. And we would just ask to continue sentencing so that he's on crutches and stitches and all that. But
I don't think I'm going to accept the recommendation of the Commonwealth in this case. Mr. Commonwealth, what was the basis for a minimum sentence and with 120 days served and the remainder probated? What was your thinking on that?
Your Honor, the case was negotiated for a settlement of 1 year imprisonment, and those were the terms. If the court would like to set it down for a settlement conference, we can look at it again. Be glad to.
Well, the reason I'm asking is, did you check his criminal record?
Your Honor, we did.
And so...
If the court would like to set it down for a settlement conference, then
well, I want to know the basis for the recommendation. He has 7 prior felonies. He's charged with operating a motor vehicle while under the influence of alcohol or drugs, 4th offensive subsequent, and he has 21 prior convictions for operating under the influence of alcohol. I'm sorry, that's for alcohol intoxication in a public place. He has 10 prior convictions for DUI. He has 7 convictions for driving while his license was suspended for DUI. He has 3 for no insurance. He has 5 convictions that are violations of an EPO or assaults or otherwise involving violence, plus a theft. He has a prior conviction for persistent felony offender. As a matter of fact, he had a felony conviction in 2009, which may have made him eligible for a PFO in this case, which wasn't brought.
The court has a lot of familiarity with this case.
I have a lot of familiarity with his criminal record because I checked it. Did you check it?
Yes, Your Honor.
So you knew about all this?
And this was, under the prior administration, was dealt with this individual, and so here he is today again. So the court wants to set it down.
What does that mean? What are you saying? I mean, obviously I can set it down. I want to know why. I want to know why you recommended this for somebody who has a 30-page criminal record with 7 prior felonies and so many counts of driving while under the influence.
Your Honor,
do you know anybody who's died because they were hit by a drunk driver?
Reject the plea, please. Reject the plea. That's what you can do. That's your job. Reject it or accept it.
I think your job is to use more discretion in making these offers in the first place so that I don't have to reject them.
Go ahead and tell me how to do my job. I appreciate it.
Well, you were telling me what mine was, right? All right. If you can't dish it out, if you can't take it, don't dish it out.
Reject the plea, Your Honor.
I do reject the plea.
Thank you.
All right, we'll set it down for a settlement conference, March 28th.
Refreshing.
Pardon me?
I said it's refreshing to have some of these rejected.
Well, I've rejected some before. Commonwealth versus Tanya Saylor, 13 CR 120.
Your Honor, Ms. Saylor was represented by Will Seidelman, and I thought I could stand in for sentencing today, and it probably would be okay, but it's a probation sentence, and if the court wanted to continue 2 weeks for Mr. Seidelman to
I'll
be
pass
here,
this for 2 weeks to Mr.
I feel
Seidelman.
better about that. Thank you.
February 20th.
Must have ended that. What's this? Yeah, sorry. Okay. Commonwealth of Kentucky versus Charles D. Goines, 13 CR 50.
Your Honor, Mr. Goins is here to be sentenced. He is very clearly PFO first, just to address that off the bat, and continues to have problems with substance abuse issues. But part of the plea agreement is that he would attend and complete a long-term substance abuse treatment program.
Has he made arrangements for that?
He's talked with Nehemiah House, but we believe that probation and parole was going to place him through their social services clinician, substance abuse clinician, once the order was in place. His co-defendant in this case was represented by Mr. Doan, is pretrial diverted on with the condition that he completes a long-term treatment program also. Mr. Goins obviously is not eligible for diversion.
Right.
And I think there was an attempt to treat two similarly situated individuals or similarly culpable individuals the same. So we would just ask that he be sentenced today and that probation and parole be allowed to assist him in.
Has the victim been consulted on this matter, on this plea?
I would shake my head yes. I know we did not represent her, but she was appointed to our department in some other cases, and she's had conflict counseling. I believe the victim's advocate or the Commonwealth spoke with her.
That's what I'm asking is, did the Commonwealth Attorney's Office consult with the victim on this plea?
Your Honor, my teams with the victim have actually been unsuccessful. The restitution in this case is zero every month.
Right, okay. So you haven't been able to get in touch with her to consult with her? Okay, I'm going to pass this for 2 weeks to allow that to happen. in 13 CR 247, Commonwealth of Kentucky versus Michael Blair. Okay, I've reviewed the pre-sentence investigative report in this case. The Commonwealth is recommending a sentence of 1 year. Has the Commonwealth consulted with the victim on this?
Your Honor.
Yes, ma'am.
Michael Wilson from the Lynch Police Department was the victim.
Yes. And was he in agreement?
We have not reviewed the plea with him.
Okay. I'm going to pass this for 2 weeks to allow you to do that.
Your Honor, we would ask in these cases that the court would enter an order allowing us to see the pre-sentencing report, and we get a copy of it.
I thought I did that a few. Okay. Right. Right. Okay.
These matters come up and we, don't have that report.
I understand. I know. When I was Commonwealth attorney, I never received one, and that always frustrated me. That's why I asked if it would be possible to give you a copy, and they have to check with their supervisors. They haven't heard back on it yet, but I am working toward doing that. I think that the Commonwealth should have that. Now, it could be that there's some rule or policy I'm not aware of, which was the reason I never had it, but I wanted to inquire about that. And the information that I was giving you before, that fellow's criminal record did not come from the pre-sentence investigative report. It came from CourtNet, which, of course, we have access to. Most attorneys have access to it, and certainly the prosecution has access to it. It takes about 3 minutes to print out a CourtNet on an individual. And so that's not some kind of secret information that's not available. Now, the PSI does have information that we don't have.
Your Honor, I didn't say I had not seen CourtNet.
Well, I didn't say that you said that.
You asked me if I had seen it, and I said I had.
Yes,
I just said I had not received a copy of the pre-sentencing report.
I understand that. I understand the distinction, Mr. Phillips. I'm saying that criminal records are easy to get. PSIs are not. So we'll see if PSIs, if it's possible to let you have that, we will. Because I think you should have that. I've passed it for 2 weeks. Right. So the officer, you can send it. The reason I'm asking on some of this, whether you've consulted the victim, do you remember a couple of motion hours ago when there was the break-in in Everett's, and I asked if you'd consulted with the victim, and you assured me you had and told me it was Benny Dale Coleman? Do you recall that, Mr. Boggs?
Sorry, Your Honor, what are you talking about?
I'm talking about a case several motion hours ago where there was a break-in in the former Everett's High School up in Everett's, and an organization was going to get $1,000 in restitution from the defendant. And I asked if the victim was in agreement with that. I did not know the name of the organization, and you told me several times that it was Benny Dale Coleman was the head of the organization. And I asked if you had consulted with him and if he was in agreement, and you said yes. Do you remember that?
Your Honor, I don't recall exactly the way that you talked about it. I do recall a case where Mr. Coleman was the president of an organization, and at one point I had talked with him about...
At one point, which was after the plea was entered, right? After you'd already told me that you'd consulted him.
Your Honor, I talked with him before that. If you'd like to bring Mr. Coleman in and put him under oath...
I'll do that. I'll do that. I have talked to him.
And I talked with him beforehand about the victim, and as it turned out, Your Honor, we offered to have community service. That was one of the issues that we talked about. We talked about community service with these defendants, and Mr. Coleman said that they were not interested in community service. I don't know if this is proper to be talking about this at this time, but nevertheless, you brought it up.
Well,
They were not interested in community service. We were talking about the damage that was done, the repairs, the repair estimates, and that it was not going to be possible, and as I advised the court that day, that the defendants, you asked me if they were in agreement with $1,000 from each of these defendants. I said that the damages exceeded $100,000, but they were aware that they were not going to get $100,000 out of these defendants, and that $1,000 was better than nothing. And that was the discussion. Now, whether or not he was in agreement with it, I didn't say he was in agreement with it. I said that he wanted $100,000, and $100,000 was not available. If the court checks the record, that's what I said.
I'll check that, because that's not the way I remember it. Perhaps I'm mistaken about it.
I think the newspaper even reported it.
Listen, don't interrupt the judge, okay? My recollection was that I asked if the victim had been consulted and if the victim was in agreement with it. My understanding was that you said that yes, they were in agreement with that plea, with the plea agreement.
Your Honor,
Now, Mr. Boggs, control yourself. I then happened to be talking to Mr. Coleman on something else, and I asked him about that. And he said no, he had not been consulted, he didn't know it was coming up in court, and he did not like the plea. Now, we'll have him in here and we'll have a hearing about it and find out. You know, perhaps you're right. Perhaps you misremembered it. Perhaps I misunderstood it. We'll pass it to the next motioner. Give me a chance to consult the recording of the motioner, and we'll have Mr. Coleman here to clarify matters. So we'll pass that matter. We'll set it on the docket for 2 weeks. It's not on today. But that's why I've been asking about the victims, whether they've been consulted or not. Because statutorily, the Commonwealth is required to consult with the victims. That's why I'm asking. Because we've had several today that have not been consulted yet. If you need more time to consult with victims, just let me know. I'll give you more time. But they have to be consulted. They don't have to be agreed with. They may want more than, they may have a different view of the case. The Commonwealth determines what the plea offer is, but you're required to consult with them. So, that's all. What's next, please?
Your Honor, in terms of that, I hope you make that very clear. The Commonwealth consults with them, but we are not required to enter a plea based upon their agreement.
Correct.
Only that they have knowledge of it.
Right. You are to make sure that they have knowledge and explain it to them and so forth. They don't control what your plea is. You can override what their wishes are. But there are cases where the victim's wishes are important to the court. I want to know what they think about it. So I want you to go ahead and consult with them ahead of time so that I can know that. All right. Commonwealth of Kentucky versus Robert